So it was like the last place I worked where we had really complicated air conditioning just switched off. Because it was more comfortable just not to have it on. And it cost a fortune to put in. Anyway, that has nothing to do with parental responsibility. So what is parental responsibility? Well, what the law said was that we need a way to identify who should have a say in a child's life. So where you've got people who can't agree, or where there are big decisions to be made, like where a kid goes to school, which country it lives in, whether it has a life-saving operation or not, you need to be able to identify, to point at the people who can make that decision, because otherwise you're not going to know. So the law decided or invented this status of parental responsibility. Okay. Now, it deliberately calls it a responsibility and not a power. Most clients, when they come in to see you, one of the first things they'll say is, what are my rights over my kids? Well, we don't really talk in terms of what people's rights are, although it does have an impact on their rights. The law focuses more on what their responsibilities are. And it comes back to that theory that the law is all about putting parenting in the sphere of the parents, giving it to them. It's their problem. They made this kid and they should be bringing it up. So parental responsibility is another central concept. Your law is more detailed than my law in terms of setting out actually what parental responsibility is. You need to know who has it, who doesn't have it, and what it means. Okay. What it doesn't dictate or tell us is where a child's going to live or who it's going to see. You can have parental responsibility for a child and never see it. That is perfectly possible. You can have parental responsibility for a child that doesn't live with you and has never lived with you. That's fine as well. But what the law does say is that if you've got a child living with you and that's under a court order, you should probably have parental responsibility. And that's so that you can make the decisions that a child needs you to make. If you've been tasked, if you're a grandparent who's been tasked with bringing up a child, you really need to have PR which enables you to pick a school for it, or to authorise medical treatment, or take it on holiday. You try in the modern era taking a child away on holiday if it has a different name to you, because you get stopped at immigration everywhere in the world. My son, my eldest son, has a different name to me because he's from my first marriage. And I used to have to carry a letter from my first husband everywhere I went, saying I was not abducting him, even when he was a 6'2" teenager. I could not have abducted him if I wanted to. It's quite an important concept. Okay. When is a parent not a parent? Well, to make it slightly more complicated and without wanting to scare anybody, it's not just about biological parenting. Parental responsibility is a concept that is bigger than biological parenting. Okay. So the law defines a father as the genetic or adoptive father of a child. Once you've adopted a kid, it's yours legally for every purpose. Okay. Or it can be the genetic father of a child. A mother is the woman who gives birth to it. In the world of donor eggs, that gets a little bit complicated, but by law, a mother is the person who gives birth, okay? Or who has adopted a child. A parent is a father or mother who has parental responsibility, okay? They are the person tasked with parenting. Very rarely will you have a mother who does not have PR. It's almost impossible. To have a mother, unless your kid's been adopted, it's almost impossible to lose your PR. You might share it with other people, but it's virtually impossible to lose it. Fathers sometimes do not have parental responsibility for a child. What makes it quite complicated is assisted reproduction. If you were doing an English law degree and you were studying family law as a discipline, we would have to go into great depth about what happens when you have a child through assisted reproduction and who has PR for it. It is very painful and complicated and has the potential to be here too. I'm not sure how often it actually comes up though. I think there's quite a lot of case law around it, but I'm going to assume it's not that much of a problem in Guernsey yet.
do you find out?
I couldn't find a case law on it,
Mm.
which is probably a good sign. It's all to do with whether you have parental responsibility for a child where you've had assisted reproduction. Will depend on various definitions given to mother and father, and sometimes where it was conceived, whether it was in a proper clinic or not. And it's also to do with consent, because of course you can make a baby sometimes without the consent of the other person. So that really does complicate the concept of PR, so I've tried not to go into it too much here. People who aren't parents can have PR. Grandparents, if a child lives with them, will generally have PR. The state, the department, can acquire PR in certain circumstances. What is it? Well, you've got a definition of parental responsibility, you lucky people. It is the following duties: to safeguard and promote the child's health, education, development, and welfare, to provide care, direction, guidance, and control in a manner appropriate to the age and understanding of the child, to determine all aspects of their upbringing, to provide a home for the child or regulate where they live, to maintain regular relations and direct contact with the child if not living with it. Notice that that's a duty. So where you've got your dad who doesn't want to see his kid post-divorce or separation, you can be saying, well, the law says you have a duty to maintain a regular relationship with your child. Can the law actually do something to you if you don't? Probably not. But the law says you have that duty because it's in the child's best interest. To act as the child's legal representative if it has to bring all defendant proceedings. And to safeguard and otherwise take care of their property. Sometimes kids have assets. The obligation to perform those duties, where it's practicable, in the interests of the child and consistent with their needs and capacity. And the right to exercise those powers. Because when you give someone a duty or an obligation, you have to give them the power, general principle of law, to give effect to those duties and responsibilities. And they're entitled to exercise that power without interference from anybody else, unless the law says otherwise. Okay. So if you are the parent of a child and you have PR for it, you can jolly well get on with it. You have the right to do so in order to discharge your obligations as a parent. Who has PR? Well, that is set out in section 6. There are people who have it automatically when a kid is born. There are people who acquire it, and a court can order it. Okay, so some people have it from birth, some people have it, they acquire it, some people get it ordered by a court. If you are married and you have a baby, you will both have parental responsibility for that child. That's the easiest one. If you've got clients who are married, they both have PR. If they're married when the child is born, where they're not married, okay, or weren't when it was born, the mother has PR. The mother who gives birth will have PR for that child. The father won't unless he has acquired it. Okay. And he can make an application. And the court can make various other rulings in relation to PR. Unmarried fathers have a whole section to themselves, section 7. And it is unusual, you'll not see it anywhere else because I think it's peculiar to Guernsey. If the child was born before the law came into force in January 2010, the father only acquires PR if they married the mother before January 2010 or acquired PR in a different jurisdiction before 2010. Okay. So you can imagine that if you present with an unmarried dad, you're going to be sitting there working out for a bit when the kid was born, when they got married, and whether he's going to have PR or not, whether he needs to apply for it. Okay. So you'll have to work through the problem stage by stage. When was the kid born? When did they get married? Or did they get it somewhere else? They might have had PR, for example, awarded to them in a different country. It's fine. After January 2010, so where the kid's younger than that, an unmarried father gets PR if they are registered as the father, so generally if they're on the birth certificate, or if he's got a parental responsibility order or a residence order, or they've had a parental responsibility agreement, or if he's married the mother, or if he's got it somewhere else in a different country. Okay. Fathers with parental responsibility, date of child's birth, any date, if they were married, before January 2010, married the mother before January 2010, or required parental responsibility in another country. After January 2010, where he's registered on the birth certificate, or has a parental responsibility order, or has a residence order, or the parents have entered into an agreement, or he marries mum, or he's got it from somewhere else. I think that what that probably means is that if you've got a kid born before January 2010, and the father doesn't marry the mother and doesn't have PR from somewhere else, I'm not sure he can apply to the court for it.
Yeah, I know there is a.
Could be I'm misreading it.
If the child is born after January.
After the law comes into force, basically, he can apply for an order.
Child's birth, right? Not the application.
No, date of the child's birth. So non-parents who can get PR, the department, where it's applying for one of those community parenting orders. So where a child is being parented by the state, or an emergency protection order, or there's a care requirement and they need PR to give effect to part of the terms and conditions of the order, or there's a secure accommodation order. The reason that is there is so that the department can effectively make use of the order that it's got. In other words, it can govern the life of the child. Okay. Again, one big difference between English law, where we have supervision orders, and Guernsey law, where you have care requirements, is that you don't get PR with a supervision order under any circumstances. But here, or rather the department doesn't, the local authority, but here you can have PR to go with a care requirement if you need one. Who else can get it? Anyone who has a residence order, so anyone that's got an order saying the child is going to live with them. A guardian under section 13, that's an unusual provision, it's not often used. It's where a parent dies and a guardian has to be appointed to take care of the child and its affairs, or where they have a parental responsibility order. So that must suggest to me that there must be an ability for unmarried dads with children older than 9 to apply for an order. It wouldn't seem right if there wasn't, but I'm not sure that's clear from section 7.
I think there's forms that you can fill in as a litigant, and if it's with consent, that you can turn up to the court and see the judge without anybody there. But I guess that's only if the mother was agreeing. If it was a situation where you didn't have that.
Yeah, and certainly parental responsibility agreements are very common, and in Jersey they don't even see a judge; they're just filed with the court.
Oh, really?
And you get one back with a court stamp on it, just saying it's been filed, and that's your PR. So it's quite administrational, really. I don't know what the procedure is here.
I don't know if you could do it if the mother didn't agree, if you're unmarried. Because as you said, there's a 9 to 10-year-old child.
I may ask Cherry about that. It would seem to me odd if the court could give PR by order to anybody else, but couldn't give it to a father because a child was born before 2010. Wouldn't really make sense to me. So it could be he'd be making an application under a different section, but I can't think that a stranger, that the court could award PR to everybody but not to a dad. It doesn't sound right to me. I just think he'd be making an application under a particular protection, perhaps. But it has been made complicated by the way they've introduced that division date of January 2010. When does it end? Normally when you're 18. Or if you get married before you're 18, then PR comes to an end. Because no one can tell you what to do when you're married, in theory. Where you only hold PR because of an order, so where you've got PR because of a residence order, so you're a grandparent and the kid is living with you, so you've got PR. You only have that PR for the length of the order. So if the residence order comes to an end when the child is 12, the grandparents will lose that. They only have it because the child is living. And the court can sometimes, it can take away what it's given, so it can cancel an order and terminate an order for PR sometimes. When will it grant a PR order? Well, with dads, it's going to be almost automatic. You have to go some now not to get PR if you can prove you're the natural father of the child. But there are cases where dads do not get parental responsibility. If a dad is pursuing an application for PR to get at mum, and we're back to domestic violence, to have a go at mum, then that's not okay. The court will, if it's contested, look at whether the father's shown any degree of commitment, whether there is a relationship between them, and what his motivation is. If he's asking for an order just because he wants to be able to control the life of the mother, in other words, restricting her decisions about where the child goes to school, where she lives, those kind of things, the court is likely to turn it down because it is a very useful tool to a domestic abuser. Enables them to track their partner and have a say in their child's life. Imagine, for example, the child of a rapist, for example, is probably a classic example. A child born through rape, so a rape victim gives birth, rapist father seeks rights in relation to the child, can possibly be granted. Occasionally, I think they have been given contact in the past, that's caused a bit of a fuss. But they could make an application for PR. The court is going to think about what their motivation for doing that is. Even if you get PR, it does not mean that you are going to get to see your child. They're separate applications, different principles apply. Some people have PR for children that they've never seen, never met. Exercise of PR, this is where the court has to step in sometimes because most kids have more than one person with PR. Okay. Classically, two parents, so they've got mum and dad, both have PR. There might be more people, there might be grandparents floating around with PR, depending on what the living arrangements are, who knows. But what happens if they can't agree how to exercise that PR? So you've got mum saying, this child is going to go to school A, and dad saying, no, this child is going to go to school B. What do? Well, there are certain things, the general rule is that you can exercise your PR without the authority of anybody else. So you don't need the other parent to agree. You can make decisions for your child on a day-to-day basis when it's with you without going to mum for her permission. That's very important because otherwise it tends to get abused and people's autonomy is cut back. But there are exceptions for that where you're making big decisions, and these are in section 9. So you can't, there are exceptions to the rule that you don't need the other person's consent. Naming or changing the name of a child requires both parents. Quite what they do if they can't agree a name. Does the court name the child? Removing the child.
Surname.
Okay. Even then, what do you do?
Yeah. Does the court decide whether it's mother?
Gives it both names? Yeah. I don't know.
I
don't know. Removing the child from Guernsey or Alderney, selecting a school for the child, selecting a religion, religion's still important, or consenting to the child's marriage. You need everybody's agreement to do that, or you can make an application for a court order. Okay. Court orders are there called specific issues orders, which really relate to the exercise of parental responsibility, where two parents cannot agree how that parental responsibility should be exercised. Whether it's which school the kids should go to is a classic one and very common. Whether they should have inoculations is a classic one and very common. That kind of a thing. So you can go to court and say, I want a specific order, sir, which permits me to exercise my PR, and this child will go to this school or will have this inoculation. Okay. That's what specific issues orders are. I don't think it's not on that list of requiring consent, but it is an issue which quite often parents will argue about, and there's certainly a lot of case oriented around inoculations. Because the flip side of a specific issues order is a prohibited steps order. And a prohibited steps order is an application by someone with PR to stop someone else with PR doing something they'd normally be entitled to do. Moving school, having them inoculated, all those kind of things. So it's a flip side of a specific issue order. So if a parent wants to use their PR in a particular way and the other parent disagrees and wants to stop them, they have to apply for a prohibited steps order, potentially. The reality is that most organisations, bodies, try to get both parents to sign up to stuff, and actually if both parents don't, they tend to back away from letting you do that which it is you want to do, really. Additional points, section 10, you can't get rid of your PR if you've got it. You can delegate it for certain purposes, but you can't give it up. You are stuck with it. So a mother can't really get rid of her parental responsibility unless her child is adopted. Person who's caring for a child they don't have PR for can still do what's necessary to safeguard that child, and that might apply to teachers or people who are just taking care of a kid. A person named as a condition attached to a care requirement must do what they have to do to give effect to a care requirement. And a person with PR can't use their PR to breach a court order. So they've got to basically behave themselves and use their PR in a way that is compatible with what the court order to do. And that's because parents can make day-to-day decisions for kids in all kinds of ways and be very difficult and make life very difficult for everybody else. And because these decisions come up on a moment-by-moment basis, what you're basically saying is you've got to exercise your PR generally in a way that fits with the orders we have made as a court. So if we've ordered that this child is going to go and live with its grandparents, you are not to turn up and try and remove it from this grandparent's house. That kind of thing. Right, so I've given you Bobby Smith. And the trick is to work out whether Bobby has PR. You've got two different children with two different birth dates. So taking each child separately, does Bobby have parental responsibility for Joe? Might he have? Does he definitely not have it? Does he definitely have it? And if he hasn't got it, how can he apply?
He doesn't have it for Joe because they're unmarried prior to January 2010.
Probably depends when he was born, doesn't it? Oh no, a 10-year-old son, so no, it's prior to 2010, you're right.
But he's an infant person.
He is, but it's still
But it's
birth
still
prior to
before
2010.
No, so he would have to get a parental responsibility order
Or agreement, yeah.
or
Assuming you can get an agreement for a child who was born before then.
I like this will want Bobby to be named on the birth certificate. Bobby is worried that Susie will change.
If he's not on the birth certificate, will he have PR?
Not if they're not married.
No.
A lot of people don't understand that. Doesn't look like there's a residence order,
No.
and it doesn't look like there's a parental responsibility order.
So the chances are that Bobby doesn't have PR for either of them, or won't have PR for either of them. Can Susie therefore remove Joe from school at the moment?
Yeah.
Yeah. So he should be thinking about making an application.
Yeah. That's an exception. Exception 9. I'm sure there must be a way that you could.
I'm sure that you can. I'm sure you can get it by court order. I'm sure you can get it by court order. You must be able to.
Yeah.
It wouldn't be in any way sensible for a father not to be able to apply for an order, because the whole emphasis of the law is on giving it to fathers, and there's a good reason not to. Really.
You've applied for a specific issue order.
To obtain a PR. Yeah.
Issue order. Yeah. Yeah.
The baby, she might enter into a parental responsibility agreement. She probably will after a bit of arguing, that's the truth of it, but otherwise you may have to make an application.
What would a parental responsibility agreement look like?
They're one of the forms actually that's attached to that practice direction, so it's worth having a look at it. I haven't had a look at the Guernsey form actually, but the English and Jersey one doesn't quite often isn't even signed by lawyers. It requires, it's a standard form, requires the parents to sign it with a witness, but quite often it's not a lawyer. So that is parental responsibility. You're right to carry on for a little while. So what we look at next is really the private law area of things. So where you've got those disputes between family members. Again, be a little bit careful when using English law. That's partly because some of the terminology is different, and although the concepts are similar, they call things different names. So we're looking at what orders the court can make to govern disputes between family members, including when they can be removed from the island, and how orders are enforced where a parent disagrees with them. Okay. Enforcement of these orders is always really difficult. Okay. It's a massive frustration to all lawyers that work in this area of law that we can spend ages obtaining an order for a child to have a relationship with its father, only for a mother to simply refuse to comply with it. She'll go out at pick-up time. I've had a couple of cases where the children have been in their pyjamas when dad has turned up for contact at any particular time of the day, or not wearing clothes or whatever. Anything to frustrate their contact. So enforcement becomes really quite important, and it's something that the British courts have always struggled with. So arrangements for children are set out in section 17. Okay. Part 4 of the law, section 17 in particular. These are orders that the court can make in family proceedings. It's worth noting that because family proceedings is very wide in terms of the actual proceedings that must have been issued before the court can make an order. The court can make an order even when no one's asked for it a lot of the time. So family proceedings is any proceedings under the children law or the matrimonial causes law or a long list of other things. Can give the court jurisdiction to make these orders. So anywhere where the court is considering the welfare of the child, a relevant court is going to be able to make orders about the arrangements for that child. Even if no one's applied for it, I will occasionally get a contact order from the court which nobody's applied for. The court is saying, I think there should be. So you don't have to apply for it. The court can make those orders of its own motion. Sometimes a judge in a public law case will make a private law order. Sometimes they will sit, listen to everybody and say, do you know what? The best outcome for this case is that the child lives with its grandparents. And we're not going to make a public law order, we're going to make a private law order. Because we don't need the state intervention here, we need family intervention, not intervention from the state. So you need to know who can apply for orders, which is where PR comes in. Because what dictates whether you can issue an application under Section 17 or a contact order or whatever is whether you have PR for that child. If you don't have PR for the child, you might need leave, so the court's permission to even bring an application. You need to know what orders you can apply for, what mixture of orders you can have, and what the principles are that the court's going to apply, so how it decides what orders to make. So what are the Section 17 orders? There are residence orders. They tell us where a child lives. You can have shared residence orders. So you can have a residence order which says, kid lives with mum 1 week, kid lives with dad in another week, and we'll call it week 1 and week 2. And they rotate. That's fine. Contact orders, which are orders where a child is normally resident with one parent and spending time with the other. Okay. It's not just parents though, other people can apply for contact orders as well. But if they don't have PR, they'll need the court's permission. And that might include grandparents, aunts, uncles, siblings. Okay. You can have applications between siblings to have contact with each other sometimes.
But then you'd still have to go through the process of getting leave to bring the application.
Siblings need leave. Specific issue orders are those particular issues where parents can't agree about something important for a kid. Prohibited steps orders is the flip side of that, stop someone doing something that their PR would normally give them the right to do. And they can apply for parental responsibility orders. Okay, it's all under Section 17, so it's quite a big section. Court can mix them up. You can have a residence order and a contact order. You can have a specific issues order and a contact order, all kinds of things. Once they've made that order, they can vary it, discharge it, whatever. The idea being that children cases are always almost under review. You are never barred from taking a case to court unless specifically the court says you can't bring an application. And that's something we'll have a look at probably later, because circumstances for kids change. So because a residence order with mum works now does not mean it will work in 5 years' time. Any order that the court makes can have directions and conditions attached to it. That can be quite useful. So I've done, for example, shared residence orders which have some conditions attached to it, which tell the parents how they're going to exercise their PR. So in other words, it says how the kids are going to, how they're going to agree holiday arrangements, or rather how they're going to dictate holiday arrangements, handing over passports, all kinds of strange and wonderful things. The court is going to apply those welfare principles that we talked about. So the court is going to remind itself of those 11 or whatever there are parts of the welfare principle and should look at them whenever it's making an order. And it's going to apply the welfare checklist, often with the assistance of your safeguarder service under their new name. The court expects parents to work together to reach agreement where possible. Sometimes the court will say we can give a consent order. So this order sets out by agreement how these kids are going to depart their time between their parents, divide their time between their parents. They may say, actually, no order is needed here because you guys are in agreement. So you can tootle off and get on with it. You don't need an order from us. Mediation is quite important when people are trying to sort out arrangements for their children. And I think your mediation service is effectively through Safeguarding, isn't it? Yeah. So can people self-refer to that mediation, or do they need referral by a lawyer or by a court? Or
I'm not sure if they do self-refer.
Yeah, because in Jersey we have a separate family mediation service, which is open to everyone who wants to pick up the phone. Yeah. So they're trained by National Family Mediation. I know your mediators. Okay. Remember the domestic violence stuff, because if this is a case where anyone suspects or alleges domestic violence, you're going to have to follow that practice direction in terms of what you tell the court. And you're going to have to think about whether interim orders are needed or not. Okay. So start out by thinking about residence orders. An order settling the arrangements as to the person with whom a child is to live. So a residence order is about where a kid lives. Okay. Often given to a parent, but it's not uncommon for it to be an aunt or grandparent. That's absolutely fine. If they don't have PR, once a residence order is made in their favour, they get PR for the duration of that order. So if a child is living with its grandparents, those grandparents will have parental responsibility for it whilst it is living with them. And so they can make those big decisions, because otherwise it wouldn't be sensible. You can have a residence order in favour of more than one person. We talked about shared residence becoming quite common. We understand that it's important for dads to be involved in their kids' lives. Tend to be made in cases where the child is spending roughly equal periods of time, but there's no requirement that it's 50-50, and circumstances vary widely, they do. Okay. And sometimes the court will make a shared residence order to reinforce, to underline the fact that they are equal parents, where they think that one parent is taking the mickey. See the case of V, which is a Guernsey case, and I look at that below, where grandparents were applying for a shared residence order for children who'd been in public law proceedings. Contact orders, section 17, an order requiring a person that a child lives with to allow the child to visit or stay with the person named in the order. That's important. Contact orders should not say, the child will have contact with dad on Wednesday from 3 p.m. until 5 p.m. That is not what they should say. They should say that mum will make the child available for contact with dad between 3 and 5 p.m. Okay. A contact order requires the person with whom the child lives to make that child available for contact with someone else.
Would you put that wording into your order?
Yep. Because an order that someone has contact with a child, strictly speaking, is wrong. Because you can't be ordered to have contact with a child. The other person can be ordered to make the child available for contact.
So it's whoever has got residence.
Whoever's got physical possession, if you want. Whether or not they've got a residence order, if they're the ones with the physical possession of the child, they're being told to deliver it up, basically, for purposes of exercising contact with its other esteemed parent. Okay. So what's important when you're looking at contact? Well, remember that section 3, specifically in Guernsey, says it's in the best interest for a child to have ongoing contact with both parents. So if you have a mum who is saying to you, oh, I don't think it's best for him, he'll be all confused. So no, sorry, that's not what the law says. The law says they should have a relationship with their dad. In England, it's almost always in the best interest of a child to have contact with both parents, provided it is safe. And that's even the case where there's been some sometimes quite serious domestic violence. But what the court will look at is different types of contact. Contact is not just dad sees child, takes it to McDonald's or whatever. It could be supervised contact, so supervised by a professional person, or facilitated by a member of the family if there's a worry about how dad's going to be around that child. Or it can be contact by phone, or Skype is very common, whether or not the adult is seeing the child physically at the same time, or even sometimes letters and cards. There are cases where I've had orders made for a father to have permission to write to a child once a month, for example. And those are in cases really where dad's quite estranged from the children, but you want to maintain that knowledge of their existence.
What is supported contact? How is that different?
So supervised contact tends to mean it's supervised by a professional, so generally a social worker or someone who's qualified to supervise contact. And it's quite a specific thing. It is following him around with a clipboard, basically, and literally into the loo if need be. It is active supervision, and that's used either where a parent is being assessed and their contact is being watched for the purposes of an assessment, or where there is generally a real risk of some form of harm, emotional or physical, to that child. In other words, you're worried about what the parent's going to say or do if it's not watched. Okay. Supported contact is a lot looser than that. It could be having a family member there, a gran, a brother, a friend, whatever, so that the adult is not on their own with the child, but with a trusted person. We have contact centres in Jersey. I don't know if you do here. You have one. That probably offers facilitated or supported contact rather than what we would properly call supervised contact. So it's probably got a centre where they can play with the child, and there'll be someone there keeping an eye out, but they won't have someone standing there staring at them, keeping a note.
The supervised is more a very one-on-one, whereas the supported there might be.
It could be a variety. It could. There are lots of different things it can look like. Be provided by lots of different people as well. Supervised contact, in its real meaning, I tend to see pretty much only in public law. I tend to. Very occasionally, our children's service will agree to have a supervised contact in a private law case, but that's normally where there are worries about safeguarding, and they say, okay, we'll help out. We'll see how it goes.
If an advocate gets appointed to the child through FPAS, and I guess that's how it would go into the agreement of private.
Sometimes you get private law cases where there are worries about the child, so enough for the children's service to be on the radar of the children's service.
Yeah.
So they might well have conducted an initial assessment. There might be some low-level domestic violence, or there might be the child's got some issues at school where people are saying all is not well with this kid, or they're sniffing around, they're not performing properly in school, those kind of things. So there are concerns, but they're not bad enough to trigger a public law intervention. They're not that worried that they think we need to be doing something. But there's a battle between the parents and the children's service of taking an interest. So sometimes they will say that this dispute is harming your child and we think you need a bit of help here. So there can be a right royal pain, I'll be honest, during private law proceedings, but can sometimes also be helpful.
Because surely maybe not surely, but the court would be likely to follow a recommendation from FPAS. So
almost always.
Whereas if it would be a real issue if you didn't cooperate with them properly, then their report's not going to be.
No. And if supervised contact is the only safe option, or facilitated contact is the only safe option, the only contact they're going to get. So if they say no, they're not going to have contact. So it's normally a bit of a no-brainer. Nobody likes it. It is very odd having someone there watching you while you are parenting your children. It is very strange. Not for facilitated contact. Our contact centres take people pretty quickly. And the social workers, if they're supervising contact, they will supervise contact, because it is they have a statutory obligation to do so where it's necessary. So they're quite good at that. But it is very weird being watched while you are trying to parent your kids. But there you go. So contact orders can take a variety of forms, don't always involve delivering child up to the actual parent in physical terms. A lot of clients do need encouragement to let their kids go for contact. Kids will only really enjoy contact with the other parent properly if they feel they have the permission of the resident parent to go. If they think they've got the blessing of mum and mum is encouraging them and mum is saying you'll have a great time, honey, go off and enjoy it, they'll have fun. If mum is in floods of tears when they leave the door, or is saying, oh no, I don't want you to go, but the court says you have to, then that is not going to be quality contact for the child very well. So the attitude of the parent is very important. It is your job to encourage your clients to promote good contact with the other parent, provided it is safe to do so. Contact doesn't just cover week in, week out, it covers holidays as well. Oh, holiday contact is a pain, because parents can never agree about holidays. Christmas, birthdays, Easter, Mother's Day, Father's Day. Everybody's got special days all of a sudden when they get divorced. Even when they weren't special before. All of a sudden they're special. I must see him on his birthday. I must go to his birthday party. All of a sudden becomes very important. And that's fine. So the court can make orders about holiday contact as well. And travel abroad. Problems with passports are dreadful. Oh, cases where kids turn up without passports at the airport for their holiday. With people playing silly buggers, for want of a better word. So the courts can make orders to regulate that. They can be quite detailed. What they tend to do is you'll end up with an order which says, on an alternating year basis, the following shall happen. Mum shall have the first week of the Easter holiday, then shall have the second. Any additional days shall be divided equally between them, things like that. Christmas year 1 shall be spent with Mum, and New Year shall be spent with Dad. Christmas year 2 shall be spent with Dad, and New Year with Mum, and therefore on an alternating basis thereafter. That's quite specific.
In case of passport, say if the mum says I'm trying to return, Dad turns out no passport. What happens?
You apply to the court for an order that Mum deliver up the passport.
Okay, then that happens, how long is that?
Well, if we think it's going to be a problem, if there's nothing you can do about it because you can't get in front of a judge, then you're going to want Mum given a very stern telling off by the judge. But don't forget, people are expected to exercise their PR in a way consistent with an order. So if you've got an order for a holiday and Mum deliberately frustrates it by not delivering up a passport, she's going to be in a lot of trouble with the judge.
What sort of trouble? What would the judge say?
Well, ultimately, if parents breach contact orders, one of the ultimate weapons a judge has is to transfer residence. And they do it. They will do it. If you push them hard enough, they will say, okay, it's going to live with Dad. And if you're lucky, you can have contact with it. When they lose patience, that's their ultimate weapon. It's a good problem when Dad says, they can, they're unlikely to, but they can. Unlikely to because if Dad doesn't want the kid living with him, with a real problem, child in care or something like that, which isn't really the intention. But yes, there are things that courts can do. You can be held in contempt of court orders as well. But where you think passports are going to be a problem, your order will normally deal with it. Will say, child will arrive with passport. Child will be returned with passport. And with certain clothing appropriate for the holiday that is being taken.
But this is only in the context of a court order, not a consent order.
No, you can do it by consent. Yeah, you can. In fact, consent orders are better because you can put within reason anything in them. You have much more flexibility. Judge isn't like to go into tremendous detail unless there's a problem. Consent orders give you a lot more flexibility. Specific issues orders, we've touched on those. Medical treatment and immunisations, case of FNF, which is an English case, which was to do with the MMR vaccine. So had a lot of panicky parents who thought that vaccines were going to harm their kids. Education is the most common one I have. Often boarding school, where parents can't agree whether their child should go to boarding school or not, or which school they should go to. Quite a lot of case law on that. You can't use them against the department. You cannot use them to try to stop the, or to make the state do something to help you. And you can't use them as if they were an injunction. I cannot say, Mr. Judge, I would like, as one client tried to get me to do once, I want you to get an order saying that he can't come to the school sports day. Okay. That is not a specific issues order. That is an injunction that has nothing to do with the exercise of PR. Okay. You do not go to sports day as an exercise of your parental responsibility. You do not stay away from the home as an exercise of your parental responsibility. So you can't dress up a specific issues order as being something else because it's easier. And it is not a domestic violence order. You cannot get a non-molestation injunction this way. Prohibited steps orders is the flip side of that. It stops a parent from taking one of the steps specified in the order without the agreement of the court, generally. So these are things that you'd normally be able to do, but the court says, oh, no, no, no. They're not injunctions. Again, they can't be used to stop an adult from turning up to sports day. Guernsey cases that I found that might be interesting to you. Case of Imrie T, 2010, so pretty quickly after the law came in. Application to change child's surname. Court held that the change of surname had no effect on the relationship, between the child and the father, and granted the order. Judge recognised that he was ignoring the law. If you read it, it's quite interesting because that's what happened. Judge said, yes, I've considered all this case law and I. That's basically what he said. But because these cases are so fact specific, they can do that. That's fine. Whatever, no one appealed him, that's fine. Imrie V, a minor, decision of the Magistrates' Court. This was about whether a residence order could coexist with a community parenting order. Now, this is interesting because this is the bridge between those private law and public law proceedings. Can you have a residence order coexisting with this community parenting order? In England, you could certainly have a supervision order and some form of private law, a residence order, for example. So here the child's grandparents applied for a shared residence order for a child who was the subject of a fit persons order, which was the old law, because this was quite soon after the law changed. The equivalent was a community parenting order. Grandparents had already been granted an interim residence order, so they had PR. Okay. Court noted the wording of the Children Law and the differences from the Children Act. England and Wales, they have Section 8, in Jersey we have Section 10. The court won't make an order in relation to a child who's in care, and if they do, it discharges the care order. Now that is, from an academic point of view, important you understand that that is one of the key differences between Guernsey law and English or Jersey law, is potentially the ability for public and private laws to coexist, orders to coexist. Under English law, if I have a care order for a child and I'm the department, a local authority in England, nobody can apply for or have a residence order for that child because I've got that right. I'm the one running this kid's life. That's why I've got a public law order, a care order. If grandma pops up and applies for a residence order and gets one, my care order in England would vanish, it would cease to exist. So the question here was, is the situation the same in Guernsey? And the answer was, there's nothing in our law which says that the making of a residence order automatically discharges the making of that community parenting order. So the magistrate concluded she could make a Section 17 order in a case where the child was the subject of a community parenting order. And if the department didn't agree, they could get that order discharged. So if they didn't want their community parenting order while the kid was living with grandparents, they could jolly well discharge their care order or their community parenting. The court held that its decision overrode the department's ability to determine how the grandparents should exercise their PR. Okay. So it basically said these two orders can coexist if the court thinks it's appropriate for that to happen. And that is different to English law.
Which is difficult to get your head around.
It is very difficult to get your head around because how can you say that intervention by the state is necessary if a family alternative is okay? And that's one of the fundamentals of the Children Act, is we interfere, the state interferes where it has to. If there is a family solution, they get on with it. So what we're saying here is that you can have a state solution perfectly legitimately, even where the family can get on with it. Which seemed to me an interesting mixture in terms of what they were trying to achieve, let alone what was legally possible. But the magistrate concluded she had the power, and if nobody liked sharing, they could get their order discharged. Shame wouldn't be true if the community parenting order was made after the residence order. Because in those circumstances, Section 51 would give the department the ability to determine where the child should reside. So in other words, it would be incompatible, but not where the community parenting order was made before the residence order.
Well, as opposed to ending the community parenting order when the residence order was granted, they said, if you're not happy with this, then you can apply for it to be
discharged.
discharged.
If you don't like this department, if you don't like being told that this is where the children are living, you think it's incompatible with your order, you can just apply to discharge your order.
But then the department's got PR as well as the grandparents.
Tricky, isn't it?
Yeah.
Yeah. But the court held that in those circumstances, the department couldn't override effectively the grandparents' PR. In those circumstances, what you're saying to the department, the local authority, is, well, we've given you PR, but we're not really giving you the power to exercise it, are we? Because the kid is living with the grandparents and you can't stop them from using their PR. So how can you give effective use to your community order? I found it a curious decision. In terms of what it was trying to achieve, yeah. I find it difficult. And the reason I find it difficult is because of that fundamental principle that the state only interferes when it has to. Because if a family order is good enough, it's good enough. What I don't really understand is why they didn't discharge the community parenting order and then make a residence order. I don't understand why have both.
Yeah.
Why not just discharge one? I don't know. I'm sure there is a reason.
They had an interim residence order before.
They did have an interim residence order, which they had already obtained. Clearly, the court wanted this kid or these kids living with the grandparents, basically. Court looked at human rights, and this is an interesting point that you need to be aware of. Looked at the rights of foster parents, because one of the complicating facts of this case was that there were foster parents who thought they had rights and should be considered in terms of the impact on them if this residence order was made. And the court said, no, sorry, foster carers do not have Article 8 rights. Right to family life for the purposes of this case, but that's quite an interesting part of it. Court can make an interim order. You know what an interim order is. Children's proceedings can take a very long time, so an interim order covers the bit from when you start your proceedings until you get your final order. And the court, when it's dealing with stuff to do with kids, can make a financial order in relation to kids as well. Which is quite interesting. And we talk about their panel orders last, who can apply for them, and when you need permission, which we call leave, but that's what it means. We talk about removal from jurisdiction. Maybe that is a good time to finish, and you guys can have a read of the activities, those last few pages, and the activities, and then we can start out tomorrow by running through them. Give you a chance to think about them overnight. What do you reckon?
Yeah. Sounds good.
So is this making perfect sense, or no sense at all, and you're even more panicking than you were when we started? It's all right, yeah. If I'm not making sense, do throw things at me. It's fine.